Hello, everyone. I'm Kevin Gosztola, and welcome to this live report on the Assange hearing, the first hearing in the U.S. government's appeal of an extradition decision that was issued by Judge Vanessa Baraitser way back in January. It's been over 6 months. During that time, Julian Assange has been in Belmarsh, even though he was discharged. He should have been out of prison. He's been sitting in jail, again, with persistent threats to his health, both mentally and physically. The pandemic has continued. We've seen ebbs and flows in it. And yet he has waited and waited and waited. And we finally have this hearing, but he's going to have to wait some more because there's a hearing that will take place, the actual appeal hearing, at the end of October. And this hearing was a hearing that seemed frivolous on its face. It seemed like it was a Hail Mary on the part of the US government to get the High Court of Justice to reconsider, rejecting these two grounds. They had already granted 3 of the 5 grounds that were requested. And those are ones we expect to hear argued in October. But we had these 2 in which a judge had said no to, where the U.S. the Crown Prosecution Service, Claire Dobbin, stepped in and insisted that the U.S. government should be able to challenge on neuropsychiatrist's expert evidence because he, as they say, misled the court. We'll get to that. And then that they should be able to challenge the conclusions based on facts by Judge Vanessa Baraitser on the risk of suicide. And both of these are somewhat linked to one another, but for the most part, you can take them separately. And they were argued and discussed in court separately. So I'll go ahead and discuss them separately. However, let me first say that the press who were waiting around on the remote video link were treated because of the ineptitude of the high court technicians to a typically private discussion by the defense attorney, by Edward Fitzgerald and Julian Assange. Julian Assange was brought back to the video link. The Belmarsh prison was asked to bring him back. Often that does not happen. And I was able to take down some details of this conversation. There wasn't anything that legally confidential shared because Fitzgerald warned him that people were still on the video link. However, Assange spoke, and I'm not going to pretend like I didn't hear Assange speak. It was really good to hear from Julian Assange and know what he felt about the outcome of this hearing. That I hope is reported in the coverage. It's definitely going to be in my coverage. And in the future, we probably won't get this glimpse into how Julian Assange is feeling about these decisions. But what we know is he said that it basically, he didn't understand it. This professor, Michael Kopelman, he said as an expert witness, he has a duty to protect people from harm, my children. He referenced a sawed-off gun. He was referring to David Morales, this case involving Undercover Global or UC Global in Spain, in which this private security agency was contracted to spy and conduct an espionage operation against Julian Assange and his family. This was evidence that was put on the record by Edward Fitzgerald to try and rebut this suggestion that there was any part of this that was arguable, or to provide the context for why Kopelman, this neuropsychiatrist, did have concerns about Julian Assange's well-being. And so, hold on one second. I'm just going to fix my mic here, and then I'll continue on with what I have to say. yeah, so we hear from Edward Fitzgerald that Kopelman was making this argument uh, about the fear and safety that the threats to safety of his family because of people like David Morales and the UC Global company that was conducting this espionage operation. And so that was intended to show that the court should weigh that favorably. I mean, so we get to this decision, and the decision essentially is, oh, it's not better audio. Let me do this. We'll dump these. You can see my head without the bulky headphones, and hopefully that is a little bit better. And it should be picking up my mic. And pull this mic a little bit closer. Let me know if any of that is a problem. But I'm going to continue. I have several people tuning in, and I want to thank you for supporting my reporting. I apologize for the technical issue and the disruption. I'll continue to give this report that I am giving. So this ruling from the judge, his name is Lord Holroyd, and Lord Holroyd is part of the High Court of Justice. He was reconsidering a prior decision and essentially said basically that this decision was one where it could be arguable. He decided that it could be arguable that Mr. Kopelman should not have had his evidence weighed so heavily. Essentially, it's incredible here. We have a strict liability offense that the United States government is trying to bring against Julian Assange, in the sense that this is how whistleblowers are prosecuted. What happens with whistleblowers in Espionage Act cases is they say you signed a non-disclosure agreement, and because you did, you knew not to release this classified information, and so you can be found guilty of the Espionage Act. Well, in this case, right now, with this particular hearing, what we were hearing was that because Kopelman signed this document to the court about what his obligations were as an expert witness, and it said that he was supposed to make all matters that he had knowledge or which he had made aware that which may adversely affect his opinion. He had to make anything he knew that could have any weight bearing on his opinion. He had to make that known to the court, and also that he had not formed that he had formed an independent view and not included or excluded anything, that there were no suggestions from Julian Assange's lawyers based upon what to put in or not put into any of his submissions to the court, any of his reports that were forming the evidence. And so essentially, in signing this sheet, that he has violated his agreement or his oath to the court, so to speak. It's very similar to what they do to whistleblowers, and Julian Assange. It's even more absurd because there's no kind of non-disclosure agreement that he signed, but they're basically trying to, indict Michael Kopelman without any evidence or testimony or anything from him, and to say that basically throw out everything he ever said. Let's discredit him entirely. Let's not consider anything he had to say based on his years and years and years of experience as a neuropsychiatrist, because on this one thing, he withheld that Stella Morris and the children, that they were conceived at the Ecuador embassy, that Julian Assange had a relationship with Stella, and that there were children who were conceived in the Ecuador embassy. So this is incredible, and the fact of the matter is that Fitzgerald said to the court that this should not be an issue of law, and since it's not an issue of law, it requires you to essentially second guess the district judge, which you can do, but it should only be if you think the district judge didn't do a good enough job of assessing all of the evidence. But if you go through the decision, you can see how she considers all of the doctors who gave evidence. There were 4 doctors who gave evidence, and there were 2 that were preferred by the prosecution, and then there were 2 that were preferred by Assange's legal team. We had Kopelman, we had somebody named Quentin Deely. Quentin Deely had evidence that went towards the diagnosis of autism or Asperger's syndrome, and then there were this Dr. Blackwood and this Dr. Fazl, who were both doctors that had, well, they disagreed with the extent to which Kopelman said his mental health would pose a risk of suicide. And so this ruling is one that I think it doesn't prevent Assange from surviving this appeal that is being put forward by the United States. But nonetheless, I think in my assessment, it could throw up a key obstacle, because if Professor Kopelman's expert evidence is disqualified in the eyes of the High Court of Justice, then it's not going to be great for Julian Assange, because there are a lot of aspects, a lot of details from Kopelman's evidence that were the basis for her decision that he could not be extradited to the United States because it would be oppressive for health reasons or for mental health reasons. And so I don't know if they can find enough from Quentin Deely to where they don't need Kopelman's evidence in order to have a kind of buffer to withstand this attack that is being lodged by the United States on somebody who there shouldn't be any question about his conclusions. Everything he did was by the book. The judge found no errors in judgment when it came to examining Julian Assange. He is in fact the only doctor who was meeting and seeing Julian Assange regularly from May 2019 to the end of that year, I believe December 2019. And these other doctors that are brought in and are favored by the prosecution have a more limited understanding and are it's not that they're bad doctors necessarily, although there are some things that are said that you could criticize, but what you find is they only were treating or giving assessments of Julian Assange over a few weeks period of time, so they can't compare to the understanding that Kopelman has of Julian Assange. He's in a far better position, and that's what Vanessa Baretzer said, that Kopelman was in a far better position to help her make this determination that, in fact, the risk of suicide would not be one that was carefully calculated by Julian Assange because he wants to avoid extradition. So let's get to the other ground. And I think essentially because the High Court decided that Holroyd decided that they're going to allow this ground 3 related to Kopelman, that they decided they have to let in ground 4 too. And they also looked at number 1, this ground that involves, I think, the assurances. And I'll have to refresh my memory here and look back to the grounds that were submitted to the court. But basically, because of the fact that they allowed earlier grounds of appeal, that then they were going to have to also reconsider so here I have it in front of me. Yeah, you've got this 4th ground. Okay, so because they had considered these other grounds, that they're going to allow all the grounds basically because they're related. So that's the conclusion of Holroyd, is that this other judge, his last name's Swift, who made the decision to reject, was maybe not considering the way that some of these things that the U.S. has put forward are interlinked. Again, I don't know about that, but you know, what is truly a problem here is that the risk of suicide, this evidence that Judge Vanessa Baretzer relied upon, was this factor that it's not Julian Assange making a calculation that he wants to escape extradition by committing suicide. So he's not plotting. He's not doing this because, hey, I don't want to go face the music for my alleged crimes. No, what he is doing is a product of these suicidal impulses that derive from a mental health disorder of which he cannot control. And because he cannot control it, then that is why this ruling is reasonable on human rights grounds of saying it would be oppressive for health reasons to extradite him to the United States. And those are findings of fact. It's important to note that in both of these grounds in which the U.S. was able to get the high court to backtrack and allow everything in, we're not talking about issues of law. We're not talking about issues related to extradition cases. These are all universally agreed upon facts, or they should be, except the U.S. government doesn't like them because it throws up an obstacle and prevents the court from being able to it would prevent them from being able to extradite Julian Assange. All right. So if everyone's still with me, I'll keep going for a little bit, but that basically gets out all of the necessary details for this case. Anybody who's following along, if you have questions, let me go through them. I'd be happy to answer. And yes, if you do like this stream, please hit the subscribe button for Shadowproof, and you'll know about future live broadcasts that are done after hearings. We'll have the 2-day hearing coming up in October. That hearing will be a more substantial one because they'll be arguing all the grounds. And so elements that we did not hear debated and litigated in court today are going to come out. And that'll be a big hearing. You know, none of this has any bearing on the ultimate outcome of this appeal, really, because the High Court isn't saying that Kopelman should be discredited. They are not saying that he does not have a risk of suicide, but you do worry because the door has been opened after it was closed. And so that means, that means that 3 and 4 are now part of the appeal. So let's go through, let's do this. I'll help people. There seems to be some confusion. And so I'll help people because let's be clear before I conclude and take any questions that everyone understands what the U.S. is appealing. So the first thing is that the U.S. is appealing and challenging the judge's conclusions of law when she applied a test under the Extradition Act and basically concluded that it would be oppressive for health reasons and then discharged Julian Assange. So there's a test there that was done, and we can get into more of that in the future. Then the second ground is that the judge, having determined that he met the threshold for discharge. Again, remember, she said that he should no longer be in Belmarsh prison. And then she said she was not going to allow bail yet because the U.S. was going to appeal. A contradictory ruling because every moment that he's in prison is making his mental and physical health worse. So on the second ground, they're saying that the judge should have notified the U.S. government that it was her view that she would be ordering discharge so that they could then offer assurances, and we put assurances in quotes, and to say that there are things they would have made declarations, they would have claimed that he wouldn't be put in these jail conditions, that he wouldn't have been put in these restrictive prison conditions. And one of the other things is that there's a treaty between the U.S. and Australia, so we could allow him to serve his prison sentence in Australia rather than the United States. All things that were well known before the judge ruled against the decision that they could have put on the record to help them win. But now, because they lost, they're saying that they would like to go back and, oh no, it's the judge. The judge is the one that was wrong because you should have asked us first, and we could have told you that we're not going to abuse him, and then you could have decided if our declarations, our assurances, as they put it, to not abuse him were legitimate or not. But again, like, they could have put that forward in the evidence and should have, because the defense team for Julian Assange says you need to put those forward so that we can contest them. You know, we need to be able to challenge what you're saying and bring witnesses forward to test them. And we didn't really quite get into it in the extradition hearing, but what we did hear was some evidence from Lindsay Lewis, who was the attorney for Abu Hamza, who was extradited to the United States from the UK on terrorist offenses. He's serving time he's in prison in ADX Florence in Colorado and suffering abuse. And there are assurances that they went back on in the case of Abu Hamza, and those have direct relevance to this now, as the U.S. is trying to save its extradition case by pointing to assurances that could be reversed if they decided it was appropriate once he is in the United States. So, you know, they'll say he's not going to be put in special administrative measures, or he won't be held in solitary confinement or administrative segregation in Alexandria Detention Center, or things of that nature. And they're talking about this treaty with Australia and how he could not serve in prison. Well, first off, what does that say about the United States? That, you know, there's no prison in the United States in which Julian Assange's human rights would be protected. So we have to offload him to his home state of Australia, which is graciously decided to take him so that we can continue this political prosecution. It's absurd. So that was allowed. And then there's the fifth ground, which I've been talking about, related to the specific findings. You know, she found that he would be held in special administrative measures. They contest that he would, you know, he's not going to be held in these kinds of conditions. They also say they will not send him to ADX Florence, Colorado. Of course, then when you read their assurances to the High Court, they go back on him and have exceptions to their rule that they're putting forward. There's, you know, if he does anything in which they might determine it is necessary to put him in ADX Florence or to put him under special administrative measures, which the Attorney General could decide, then that's what would happen. So with those loopholes, they just really aren't assurances. I don't think you can use that word unless, I mean, obviously the U.S. government is in the business of using words in a way that deprives them of any meaning. But that said, it should not be taken as assurances if you are saying there are exceptions to how he could be handled. That maybe he could be in SAMS. Maybe he could be put in ADX Florence. Maybe he could be put in this unit with others. That's a hellhole that has been documented, and there have been lawsuits challenging the treatment of people who are put in there, especially those that have mental health problems. So that's the fifth ground. And so you have those three grounds, and if you're following me now, we'll add the other two, which involves Professor Kopelman, this neuropsychiatrist, and then the idea that the assessment of Julian Assange's risk of suicide was done inappropriately by the judge. And so basically what you're left with is that we're going to have, in many ways, not entirely, but in many ways, you're almost getting a do-over for the extradition trial. It's not supposed to happen that way, but effectively, you're going to let the High Court justices second guess the primary decision maker, Judge Vanessa Bretzer, who made this decision. It's as if she never ruled on all of these facts. So the High Court of Justice is going to get is going to look at this another time. The U.S. government gets a do-over, and they get to say to the High Court that we want these facts to be weighed because they help us. We want these facts to be thrown out because they help Julian Assange. And now go issue your decision, and hope that they're able to convince the High Court of Justice to do as they request. So that's where we are, and I wouldn't say that it is a certainty that they prevail in this appeal, but they're in a much better position now than they were before this hearing, because they've succeeded in getting the High Court to allow them to appeal everything, anything that they wanted to appeal in this. And once they restore all of these grounds related to the assessment of his mental health conditions and risk of suicide and how he would be treated in the United States, if they get a lot of this thrown out, then it's back to where we thought we would probably be, because obviously it wasn't expected that Vanessa Baraitser would rule in favor of Julian Assange and protect him the way she did back in January. And so you're left with this thought in the back of your mind, does it really matter if a district judge makes a ruling against somebody based on human rights? If it's just this easy, if it's just that easy for the U.S. to find little technicalities that should have no bearing on the substance of this case, and use those in a way that are beneficial to them, to salvage a case that they really should have no ability to continue pursuing. And let's pull back. We've been talking about this in the context of this first appeal hearing, but it is necessary to have that 30,000 feet above sea level, or for people who are not in the U.S. I'm sorry, I'm not able to convert that to kilometers or meters, but high up in the air, let's look at this case. And the big deal is that there are no press freedom groups, there are no human rights groups that are saying that this prosecution should continue. They have pointed out that Julian Assange is a publisher, he's a journalist, he deserves protections, he's being targeted for the publication of information for his work with WikiLeaks. They are concerned about the way in which the justice system in the United Kingdom, the way the Justice Department in the US has gone after this case. They point to issues of due process in Sweden. They point to issues with Ecuador, and all of those add up to the psychological torment and the human rights abuses that we have seen that have been carried out against someone who should not be suffering this kind of a political case. We know, obviously, why the US government continues to press onward with this and keep Julian Assange in this state of legal limbo. But that does not mean that we accept the legal limbo that is being imposed, the kind of stress that is being imposed and anxiety that is being imposed, the way that these lives of people in Assange's family and his professional colleagues have been disrupted, the way that resources are being depleted, and he has to focus on this lawfare that is ongoing by the United States. Whether they actually allow this to go to its conclusion where he is brought to the United States and put on trial or not, they are using the extradition process in the courts in the UK in order to continue to neutralize Julian Assange, because they do not want him to do the investigative journalism that he was doing with the WikiLeaks outlet. So I think that is obviously how we should consider this and how we should see this preliminary hearing and what the U.S. is doing. And I'll say also that there is no official in the Biden administration currently who is willing to state on the record their reasons for why this should continue. There's video of Antony Blinken, the Secretary of State, who has to worry about what this is doing to the U.S. and its image. We were concerned about the image of the United States when Donald Trump was president. What is it projecting to the world that the U.S. is prosecuting a journalist? He's been asked about what they're doing. He won't answer. I will conclude here, and I suggest for those of you who haven't been able to hear that maybe you turn it up. Also, let's hear from some other people if there's any other difficulties with the audio. It's something we'll remedy in the future, but it seems to be working for most people. So for the one or two of you, I will encourage you to turn your computer up, make sure that the volume is working. With that nod to the low budget tech here, I will go through some of the questions that we have, and then I'll wrap up this live report. But thank you all for tuning in. But let me first take a moment. Just I want to put that up. This is the newsletter that we're doing, and it's from Shadowproof. There's a free. There's also a paid subscription. If you want to ensure that I continue to be able to get up early in the mornings and do this work, I don't know if any travel is going to be required for October, but you never know. So there's a 2-day hearing in October. We plan to have coverage of the appeal hearing in London, and by subscribing to this newsletter, you're ensuring that this journalism on the Assange case is able to continue, both as free and paid subscribers. So the reports that we do today, I'm actually going to be working with Mohammed Al-Mwazi, and he is going to do a report on the one ground involving the risk of suicide and how the court ruled. And I'm going to do a report on what went down with the effort to discredit Michael Koppelman, the neuropsychiatrist. And then those reports will exist side by side, and people will be clear on what just happened today with the High Court of Justice. And perhaps at some point, Mohammed and I will get together and we'll talk about it and share our views and thoughts about what we saw happen with the High Court of Justice. There'll be plenty of time to kind of take in and consider what lies ahead for Julian Assange in this case now that the U.S. government has managed to prevail on in getting these two grounds back into the case. So thecenter.org there, and let's get to whatever questions you'd like me to address before. Who were present today of the media? I heard there were 2 seats available. Oh yeah. So Craig Murray has been doing some excellent work, and I say it's really a shame that he was not there to cover these proceedings. He's in prison. Our thoughts are with him and his family, and hopefully he can find some way to follow this proceeding in October. It's possible that he might be on home confinement. I wonder if he would be able to get on with remote video access, or maybe because of the nature of his case, he would be barred from doing so. But in any case, solidarity with him and what he's going through. That is a press freedom case. Hold the. So if anybody wants to donate, I would say don't give to Google, YouTube, and the super chats. They've been withholding our donations and not giving us any of the money. Find the tip jar, which you can find on thedissenter.org. Give through the tip jar on thedissenter.org. Do not leave a super chat. We will not get any of the money from the super chats because Google has failed to do the verification of our address. They claim that they sent something to us so that we could verify our address. I don't know what happened to it. We haven't verified our address. I think because we haven't verified it in a timely manner, that we have this channel and we're eligible to bring in money, but we're actually not monetized, and we have seen no money from it. So, and I suppose it's disabled because of the fact that YouTube probably automatically disabled it. We didn't disable it. We were receiving some of that. Yeah, no. I mean, don't be evil was once Google's motto, right? And they've since veered quite far away from it. And I realize that there are a few of you out there who have given to us in the last 6 to 12 months who would have liked us to receive your money. I hope that they unlock it and give it to us, but I am not that hopeful. So I would say save your money, and let me do this here. So do this. You can give this way. Do it this way. I'm gonna send people to Shadowproof, but there's also gonna be tip jars at the end of my coverage of the Assange case today. There'll be a tip jar at the end of Mohammed's report today. So to help us continue this, we're hiring Mohammed, we're paying him. Any of these donations will go towards having him be a part of the dissenters coverage. All right, so we go here. This is a simple link for people. I'm going to drop it right there. There you go. Shadowproof.com/donate. That's the link. We'll also make it a banner right now on the spot while we're doing this. So shadowproof.com/donate. There you go. Thank you for everyone's interest in supporting. We really appreciate it. This is how independent journalism thrives and survives. So continuing on here, I'm going to go back for the people who have been waiting for a long time. And all right, so hopefully we cleared up the confusion about points 3 and 4 that are now part of US's appeal, but if not, let me know. And then we have this from Lydia. So I just want to say thank you to Shocking Travesty. Thanks for the update and explanation. Drawing the case out is a killer in itself, indeed. And yes, it was good to be able to hear Julian directly, even though we were not really supposed to, and or maybe he wanted us to hear him speak. I'll leave that up for you to decide. I asked a question unrelated about updates on Joshua Schulte. Is he still in prison or out? Joshua Schulte is still in prison. This is the alleged Vault 7 leaker. There was a mistrial in his case, and the Vault 7 materials were CIA documents or files that were published by WikiLeaks. They were not able to prove that he was the source during his trial. He's still in harsh prison conditions. He's under SAMs. He's being held under special administrative measures. So it is connected in some way to this extradition case, because the treatment he is experiencing very well could be the treatment that Julian Assange experiences, though the US government would deny that. We've got some more people here. Let's see, any other questions? Yeah, John Pillager just said this court passed the buck. And what about the confession of the Iceland witness that he lied about everything? Ultimately, it doesn't have much bearing because that's not the ground in which the extradition was denied. So what Ziggy had to say doesn't really go towards anything of relevance to the US appeal. So the US is saying basically that Julian Assange's human rights should not be protected. They're saying the doctors are wrong. He's not at risk of suicide. He doesn't have impulses that he can't control as a result of his mental health disorder. And they are also saying that this doctor, who's well respected and has been working for, I think, decades in his field, should be discredited because he protected the safety. He made this consideration for Julian Assange's family. So he's biased. So let's chuck out everything he had to say. So that has nothing to do with Ziggy, and so we won't be hearing about Ziggy's and the corruption around the case from the FBI's pedophile informant. What's the earliest date Assange could be released? Well, theoretically, if he prevails in his appeal, I suppose by the end of the year he could be allowed out of Belmarsh prison, but that depends on what happens. So let's be hope-filled, but and not necessarily hopeless, because there's a possibility for hope. But obviously, we recognize that the U.S. could come out on the winning side, which would then mean there'd be an appeal at the Supreme Court, and likely, for sure, he would stay in the Supreme Court. But I think this is going to be appealed all the way up to the Supreme Court either way. So then the question becomes, how does the High Court of Justice handle the fact that it's going to continue on to the Supreme Court? It's the last stop for the U.S. before they have to concede defeat. So this is part of that legal strategy that people talk about, with the legal limbo being part of the punishment. The process is the punishment of keeping Julian in prison through this case, whether it's a win or a lose or a loss for the U.S. government. Don't want him working on his own case either. Thank you, DB, for tuning in. Had to go, but we'll continue following. Is the hearing in October the last one? Will it then be over? No, it will not be over at last. And what's the next step for Julian if the U.S. would lose? Still keep him in jail because of the pathetic, farcical breaking the bail reason. I think I addressed that. And then everyone, thank you for letting me know about the tech. I have nobody else helping me. I'm doing this solo, so I rely on you to let me know if there are any tech issues. So keep that in mind for the future. If something's not working, do let me know. We'll always trust you that something needs to be adjusted. And then let's see, back to the latest comments from you and Greg's rhetorical. Why are they so afraid? What did Snowden post? Let's see what Snowden had to say about today. Snowden had to say, he posted a clip from Rising. Oh, they had Marianne Williamson on. Okay. And he's sharing some of the links from Stefan Simowitz, who is with Amnesty International. And these are from a little while ago. So Snowden's followed some of my reporting on the case, and I thank him for doing that. Anyways, I think it's time to wrap up this broadcast. We'll just note that there will be tomorrow a live broadcast with filmmaker Sonia Kennebec on her films that she's made. She's a chronicler of national security whistleblowers. We'll be discussing Matt DeHart, whose case kind of brings him into connection with WikiLeaks. It features in the story about him. The film is Enemies of the State. And then there's a reality winner doc that she directed that I'll be talking to her about. Then there's also National Bird with Daniel Hale in it and other drone whistleblowers like Lisa Ling. So I'll be talking to her about these movies that she's been making and her work and the independent filmmaking and how crucially important it is for somebody to be telling these whistleblower stories and putting them on film. So you can tune into that, and that will be a continuation. And so with that, I need to get to writing my report and also getting Mohammed Almazi's report published. He was at court today. We were both at court today. There were several reporters there today. I don't know about the establishment press, but let me just say that the people who have been with us every step of the way were there again. People like Mary Kostakidis in Australia, Richard Medhurst was there. New person, Chip Gibbons, joined to cover for Jacobin. We'll be writing something for Jacobin magazine. And then Tariq Haddad was there. He's been following Taylor Hudak, who does the coverage for Activism Unique. Was there. And so a lot of the people who have been independently doing this work and dedicating themselves, I don't know why Stefania Marizzi was denied access. I know that she noted she was denied access, unless she said something about why she was denied access. I mean, I can't say for certain whether it had something to do with the court denying her. I wonder if she had something that she had to be doing. She was traveling. So she says that she was given remote access 20 minutes before, and was denied access. She was not able to join because she decided to travel because she was denied. So there was no reason to block off her schedule for the hearing. This is really sad. For those of you who don't know who Stefania Marizzi is, let me just fill in that gap, and then I'll sign off. Stefania is waging this monumental Freedom of Information Act lawsuit against the UK, United States, Ecuador, and Sweden, seeking documents about the way Julian Assange and WikiLeaks staff were targeted by the police and the judicial systems, what went on with the Swedish case, what went on with the Ecuador, the seeking political asylum, and the kind of lawfare and efforts to spy on them that likely has gone on for the past decade. And she's trying to unravel the secrecy, and did so far with some success. They tried to say that somebody who isn't from the UK couldn't request documents from the United Kingdom, which would have been a horrible decision. Would have affected me in the US, would have affected all journalists have any idea about what a powerful country in the world, and obviously a client in many respects of the United States. They would have been able to shield and protect their security agents and U.S. security agents, military officers, and that was ditched as a justifiable way to block people from getting documents. So Stefania's winning in the FOIA case and pushing onward to get these materials. I imagine it vexes the British authorities. I don't know if that filtered into the decision not to give her this access. I'll say that the bureaucracy around this has been bumbling and fumbling, and it wasn't until 16 hours before the hearing today that most journalists were given the remote link for access or notified that they had a credential. So you couldn't really plan ahead for this. We're fortunate, actually, with the pandemic that, we're able to not travel internationally and still follow these proceedings. It's great for me as an independent journalist. Those expenses are really substantial, and I don't have to take those on. And I think it's owed to the pandemic that we've had this kind of access. It's not like the court would typically grant people access to the proceedings based on where they're located around the globe. Oh, they would say, well, you got to get on a plane and find your way to the UK and try to get a seat in the Royal Courts of Justice. So I don't know that this is a hearing or a case in which they would, if there wasn't this continued threat of the spread of COVID-19, I don't know that we would be having as many journalists on
remotely to follow. There were a few dozen who reported, and I think there will be a lot of posts today and into the evening on the Assange case. So I need to go and I need to write my report, and we'll have Mohammed's report. We'll send it both out. We'll send both of these out to people so that they can follow. Amnesty International was granted access. For the first time, they were not allowed into the courtroom during the extradition trial, but they were able to get in. And then we had Rebecca Vincent was given a seat in the courtroom for Reporters Without Borders, finally. Didn't have to get up 5 hours before court was to be in session in order to get a seat. So that's all good. It's really good here. I think that the press showed up today. The press that matters to me the most showed up today. We have a lot of good independent journalists. Find them, support them by sharing their work. And of course, I would be doing myself a disservice if I didn't shamelessly plug myself as I sign off here. Say, support the work of this dissenter and Shadowproof, and support this piece that's coming up from Mohammed as a guest contributor for the dissenter. And until next time, this won't be the next time you hear me talk about Assange, but until the next live report from the Assange appeal hearing in October, I bid you farewell and say I'll see you around. There'll be plenty of more shows and discussions of the Assange case in the meantime. But for everyone, be well, and I'll see you soon.